Hi, my name is Dawn DeManna, and I am an estate planning coach and attorney and pastor in New Hampshire. My law firm serves all of the state of New Hampshire, and I coach on estate planning all throughout the United States. Thank you for taking the time to be here this evening and join me on this very important topic and educational presentation. At the end, you will be offered the opportunity to work with me. If you choose not to, that's okay. I just really am passionate about educating people. So today we're going to walk through the basics of estate planning. But before we begin, I want to just say that the fact that you are here at this presentation says a lot about you and perhaps your desire to be informed so that you can plan for your future and make wise decisions about how to protect yourself and your loved ones. I'd like to start first by telling you a little bit about me. And this is me and my family, as you can see on the screen. My husband, Mark, and I have been together for 42 years and married for 35 years. We have two daughters, a son, and a daughter-in-law who are our whole world. And having a comprehensive estate plan really helps ensure that they'll be safe if anything happens to us. I'm very close to my family, and our children have very important roles to play in our estate plan. And as you can see from the picture on the top left, Mark and I love to four-wheel, which is really a fun hobby, but it is also a little dangerous, which is another important reason to have a plan, because you never know what might happen. So a little professional background about me. As I said earlier, I'm a pastor, I'm an attorney, I'm a coach, and I bring something from each of those to my new way of estate planning. As an attorney for over 17 years, I've seen what no planning or poor planning does to families while they're trying to grieve. I've also seen this as a pastor, and additionally, I've come to see that passing on your spiritual wealth, your intellectual wealth, your personal values, and family stories are important to families and can comfort loved ones in the grieving process. When meeting with families who have lost a loved one, I know how those stories are often the lost when someone becomes incapacitated or dies. And, because you just don't think to write them down or record them or memorialize them or even ask the questions to get those stories out. So even if you have an estate plan, I'm sure you haven't done that piece of estate planning that I do as well. When meeting with life or business coach clients, estate planning clients, I understand how many people avoid difficult conversations, such as death or incapacity. I realize that the traditional way of estate planning is failing families, and it doesn't line up with what I want to offer. That is why I adopted a new way of approaching estate planning that is more comprehensive, holistic, and serves families, and am passionate about educating as many people as I can about this important topic. So in implementing this new way of approaching estate planning, I can honestly say that I have never been more fulfilled in my career and that I was meant to do this meaningful work. Estate planning is a unique area of the law because I get to use my compassion and my empathy, as well as my legal skills and knowledge and coaching skills, to lovingly guide people through what can be an emotional and overwhelming process where people are forced to face their own mortality. Yeah. It can be a scary topic for a lot of people, but it is unavoidable. We will all face it at some point. And I firmly believe that if we plan for this inevitability, it will allow us to live each day with full of love and full of purpose. and with peace of mind, knowing that our loved ones will be taken care of and that they will know what to do when the time comes. So this is my why. This is why I do what I do now. This is why I care so much about helping people. And this is why I'd love to help you protect your family. You have an opportunity to choose the path that for your loved ones based on your unique circumstances and values. And I'm here to teach you how to make that happen. One last thing I'd like to mention before we begin is that you should have received a Facebook message from me with a link to the worksheet. Please keep that handy and updated as we move through the presentation. And I ask you about what's important to you. There will be a time for questions at the end of the presentation, so please write down any questions as we move through. So before we begin, on your worksheet, I'd like you to write down on that who are the important people in your life who you want to protect. Write their names down, bring their faces to mind. Go ahead and write them all down so that you can visually see who it is that you're here for tonight. Now, by a show of hands, how many of you have a plan, an estate plan? Well, actually, everyone's hands should be up because if you haven't created a plan, the state of New Hampshire has a plan for you. My goal today is to educate you about what will happen to you if you become incapacitated without a plan, and what will happen to your family and your estate if you die without a plan. You will also learn about what you need to do to have some peace of mind, knowing that you've made the right decision for your family, so that when you pass away or if you become incapacitated, things are as easy as possible for the people you love the most, those names you just wrote down. But, and this is a big but, not all estate plans are created equal. There is an old school way of estate planning, and then there is the way that I handle estate planning. Let's talk about the old way first. That is a way, that old way is very document driven, and it's not comprehensive and typically not customized, which can result in a plan that fails when you need it to work the way that you intended for it to work. This can leave your estate open to probate, open to estate taxes, and can resolve in a conflict among your loved ones. Not having a plan, or having a poorly drafted plan, or having a plan with a lot of holes, or having a plan that is not updated regularly, and by regularly, I mean every 1 to 3 years, or not receiving proper guidance about what to do with each of your assets, can all leave your estate exposed. Your assets could end up going to your children without any protection, leaving them vulnerable to dangerous or irresponsible behavior and open to predators who will know exactly what your child inherited, because probate is a public process that allows anyone to access information about it. And if you're not financially organized, some of your assets could get lost. Assets go missing all the time because surviving loved ones are unaware of the assets that have been accumulated because they've not properly been accounted for or written down anywhere. The New Hampshire Department of Unclaimed Property has unclaimed assets worth over $172 million. This happens when someone dies and their family overlooks an insurance policy or a bank account or an investment or retirement account. And this could easily happen to you if you have not and do not get financially organized. And make sure that your family knows what you have in the event of your incapacity or death. So again, if you have an old plan or no plan, or a plan that is not comprehensive, you may not be accomplishing your planning goals. Now, I talked about the old way, but here's the way that I approach estate planning. My focus is not on one and done document transactions where clients place their estate plans in a drawer or a binder on a shelf and never look at them again. You see, I want to build a lifelong relationship with my clients and help them keep their estate plans current with changing laws, changing assets, and changes within their families. I also don't push one size fits all plans, since every one of you has a unique need and wish for your loved ones and for your legacy. I work with you to design customized plans that meet all of your estate needs and goals, and I am here for you as your needs change over time. And as a coach, estate planning coach, I incorporate in helping you have those difficult conversations with your children or your spouse or your loved ones about what are your goals, what are your values, and how can we live life to our fullest. Our relationship begins with what I call a life planning session. It's an hour where I help you get more financially organized than you have ever been before, so that none of your assets get lost to the unclaimed property division of the state of New Hampshire. I also take that time to educate you about how estate planning works and all of the unique customizations that are available to you so that you are empowered to make informed choices for your family, and so that you don't get a one size fits all cookie cutter document that are likely not to serve you and put your family into court and conflict. So remember how I said everybody really does have a plan, even though you haven't really had a plan? So let's review the state's plan for you. If you don't have an estate plan and you become incapacitated or die, every state has laws that control what will happen to you in the event of your incapacity or your death, all of which involve going to court. Let's talk about guardianship first. In the event of your incapacity, your loved ones will go through a court process called guardianship, where a judge will appoint someone to make decisions for you, including what to eat, where to live, what medications to take, full control over your person, your physical body. And they will also give someone control over your assets. You may recognize this as what has been happening to Britney Spears, as that has really been in the news recently as she tries to terminate her conservatorship where she lives. All states call it something different, but here in New Hampshire, it's guardianship. So that's guardianship over the person and over your finances. Two different people, ongoing, long court process. Now let's talk about guardianship over a minor. If you have minor children and you do not designate guardians, your wishes and memorialize all of those, your children will go through the court process called guardianship, and the judge will decide who will care for your children. And it may not be who you want. Now let's talk about probate. If you die without an estate plan, or you die with a will, or you die with a poorly drafted trust, or a trust that is not funded properly, your estate will go through a court process called probate. Now, probate is the process during which your assets are transferred to your heirs after your death. The state's probate laws will determine where your assets go, when they go, and how they are to be distributed, which may not be the person you want to receive them, in the amounts that you would want them to receive, or how you would want them to receive those assets. And probate is slow. Here in New Hampshire, it takes a minimum of 6 months, with many taking much longer than that. Also, keep in mind that your loved ones probably won't have access to your assets during a probate, but they would if you owned your assets through a trust. Who would you rather have immediate access to your assets? Your creditors or your loved ones? Also, court is expensive. There are attorney's fees, executor administrator fees, appraiser fees, court filing fees, bond premiums, and creditor claims. Probates are costly in money and time and energy for your loved ones, all while they are grieving. The good news is that these fees can be easily avoided with a few $1,000s spent on a basic foundational estate plan. Another big downside to probate is that it is a public process, which means that anyone can go in person to watch the hearing, or they can go to the court's website and download the probate case notes to see the details about what is being inherited and by whom. As you can see on the screen, this is the will of Michael Jackson. I certainly didn't probate that estate, so how did I get it? Well, you can get them online. You can see the will of Richard Nixon, JFK, Princess Diana, John Lennon, Whitney Houston. All of their estates went through probate. The point is that a will is accessible by the public, and having a will doesn't avoid probate. In fact, it assures probate, because where there's a will, there's a probate. And when a will enters probate, it pulls all of the creditors out there and puts them on notice that your loved ones will be receiving an inheritance. The only plan that is private, avoids probate, ensures that your kids receive your assets when you want them to and how you want them to, and can save your estate a substantial amount in estate taxes, is with a comprehensive estate plan that includes a fully funded trust. But we'll talk about that more later. For now, if you want to make sure your family stays out of court, mark on your worksheet right now, I want to keep my family out of court. Just make that little check. Finally, and worst of all, as I mentioned previously, your children would be entitled to all of your assets outright with any restriction at 18 years old. There's a lot of responsibility. That's a lot of responsibility to put on a young adult who doesn't have their parents there to guide them. And if you have minor children, the court will have to supervise the management of the money and the assets that they inherit until they're 18, which is expensive and a huge hassle. I've heard horror stories about children who inherited large estates as teenagers. In some cases, they burned through their inheritance within a few years. And you can imagine all the irresponsible ways an 18-year-old could spend large amounts of money without supervision, and the risks that poses to their health and well-being. In other cases, it took them a little longer to spend all the money, but by the time they've spent it all, they realize that they don't have a plan for life. A friend's husband received about $50,000 when he was 18, and then another $150,000 when he was 21. As a result, he didn't graduate from college until he was over 30 years old, and he never really learned to support himself financially. So if you have minor children at home and you want to make sure they do not receive everything you are leaving behind at 18 years old, please check that on your worksheet. I need to make sure my kids don't inherit money at 18. There are also some additional tools available to you if you want to make sure that your kids, your adult children, or your beneficiaries receive their inheritance in a way that is protected from lawsuits against them, from future creditors, or even from a future divorce. For example, let's say that you get married and then you inherit a big chunk of money. Since it came to you outright while you are married, if you ever get divorced, your ex will likely get half of your inheritance. if that inheritance had been put into a protected trust, you could have used that money however you liked and kept it all when you got divorced. So if you want to ensure that your children's inheritance is protected from lawsuits and creditors or future divorce or even their own poor behavior and action and choices, no matter how old they are, mark that on your worksheet. Before we move on from talking about your kids, if you do have minor kids at home or know someone who does, I want to tell you two quick stories that can illustrate where your kids are at risk, even if you've already named guardians somewhere else. First, if you haven't named guardians, you're in good company because 69% of parents have not. If you don't name guardians and something happens to you, the choice about who raises your kids will be left up to the judge to decide without any input from you. Let me illustrate this with a true story. Several years ago, the Barber family, 2 parents, 3 sons, went on a road trip from California to Arizona. While they were in Arizona, they got in a car accident and tragically, both of the parents died. The boys survived, and when the authorities finally found a family member to pick them up, they found one of Mom's sisters. That sister decided that she wanted custody of the kids and their buddy and prevented them from seeing any of the other family members. After more than $100,000 in legal fees and nearly a year of litigation and a huge family fight, a judge decided that a different sister should raise the boys and appointed a financial conservator over the boys' inheritance to the tune of $100 an hour. And the boys would receive whatever was left at the age of 18 outright. But it doesn't have to be this way. If you want to make sure that you get to choose the people who will raise your kids in the way you want if something happens to you, check the box on your worksheet that says, I need to name guardians. Or perhaps you know someone who has minor kids that would want to know this information. Write their names down. Now, even if you have guardians named somewhere in some old paperwork that you had done, perhaps a will, they could still be at risk. Let's say that you and your spouse are out on a date and your child is home with a babysitter. Even if you have named guardians in your will, what if those named guardians don't live nearby? And how would someone know where to look for your will? If you got into a car accident on the way home, even if you don't die and were just temporarily incapacitated, the authorities would have no choice but to take your children out of your home and into the care of strangers, like Child Protective Services does, until they can locate your will or locate your named guardians who might live far away or be out of the country or on vacation. That is why I prepare something called a Kids Protection Plan as part of my comprehensive estate plan. A Kids Protection Plan ensures that your children are never at risk of this happening to them by filling in the gaps in traditional estate plans. If you want to make sure that your kids are never taken into the care of strangers, mark on your worksheet that you need a Kids Protection Plan. And the other reason you may want to mark that down is if there's anyone in your life you would never want raising your kids. A will does not exclude anyone from guardianship. And if you know you would never want a specific person raising your kids or challenging your choices, you'll also want a Kids Protection Plan. So mark that down on your sheet. Now, we've talked a little bit about what would happen to your minor kids and to your assets if you became incapacitated and when you die. But what about what happens to you and your related healthcare decisions if you become incapacitated? Well, if you were alive in the 90s, you might remember the case of Terri Schiavo. She was only 26 years old when she had a heart attack and ended up with severe brain damage from the lack of oxygen in her brain and fell into a coma. She eventually emerged from her coma, but remained in a vegetative state. She didn't have a healthcare directive, So she had not documented end of life wishes or named agents to make medical decisions on her behalf, or even had that discussion with any loved ones. Her husband and her parents couldn't agree about whether to stop life support. After 8 years in a persistent vegetative state, her husband petitioned the court to remove the feeding tube, but her parents objected. And they ended up going back and forth in court in a case that went all the way up to the United States Supreme Court. Now, when the Supreme Court declined to hear the case, the feeding tube was removed for the third and final time, and she was finally allowed to die peacefully. 15 years after she fell into a persistent vegetative state. These terrible events and this 15-year saga could have been avoided if Terry had an advanced healthcare directive. Now, many of you have executed such a document, but in many cases, they are out of date or they won't work the way that you want it to when you need it to. And you probably haven't had those hard conversations that are necessary with your loved ones who you've named. And chances are that is not comprehensive enough to provide detailed guidance on how you want to be cared for in the event that you become incapacitated. My daughter, Kim, who is on this call, is a doctor in Colorado and has seen firsthand that many people, especially younger people, do not have a healthcare directive. She has seen firsthand when family members disagree about the course of treatment for their loved ones who have no directive. It can tear families apart. So if you have specific wishes that you want to make sure are honored during your incapacity and specific wishes for how you want medical decisions made for you, mark on your worksheet, I need to update or review my healthcare directive. Now, many people think they can avoid having a comprehensive estate plan, as I've shared, by either owning property jointly, designating beneficiaries for their assets, or signing a will. Joint ownership also has some issues. If you own a home, you may remember when you were in escrow, you were asked how you wanted to take title to your home. Some of you may not remember. If you're single, you just said in my own name. But if you're married, you probably said as joint tenants. If you took title as joint tenants, you have the benefit of avoiding probate upon the death of the first spouse. Sounds good, but the downside is that you can't ensure that the surviving spouse won't give all of the property away to a future spouse or lose the asset to creditors. Another downside is that the surviving spouse may have to pay a large but would be avoidable capital gains tax if they decide to sell the home. And what happens if you both die at the same time, like in a car accident? Well, in that case, the house will go through probate. The only way to ensure that your home doesn't go through probate is to create a trust that owns your home. Designating a beneficiary is another strategy for avoiding probate that people use for certain types of assets. But many assets don't have this beneficiary designation. But where you can designate a beneficiary, the beneficiary has unlimited control over the assets once they receive them. And if that named beneficiary is dead at the time of your death, the asset will go through probate. Worst of all, naming a minor as a beneficiary just ensures that your insurance or retirement account will end up in court if you die before your kids are 18. And your kids will own the asset outright at 18 years old. And as I already mentioned, signing a will won't work either because wills go through probate. The only way to keep your family out of court, either in the event of your incapacity or your death, is to have a comprehensive estate plan with a fully funded living trust. This means that you have a trust that is properly drafted and is customized for you and your unique family to say exactly what you want to happen to your assets in the event of your incapacity or death, and that all of your assets that can be owned by your trust are actually owned by your trust, and that all your beneficiary designations are up to date and your trust is listed as a primary or contingent beneficiary. It's worth noting that whether the trust is the primary or contingent beneficiary is really important because it can trigger a taxable event. So you need to work with an attorney who can guide you through these very important decisions. If you already have a trust, chances are it hasn't been updated since you created it. So it's likely out of date because the laws have changed, or your life has changed, or your assets have changed. And it's also very likely that your assets are not all properly owned by your trust, and your beneficiary designations are not up to date. I see this all the time when I help clients who come to me to update their existing estate plan. The father of a different friend of mine spent $3,000 on an estate plan that didn't work when his family needed it because it had not been updated and his assets were not properly owned by his trust. As a result, his kids ended up in court with his ex-wife, and of course, that cost a lot of money, and it was a very stressful experience for his family. This is the type of experience that can result from inexpensive lawyers who use cookie cutter form documents, who don't properly guide you to make informed and empowered decisions, who don't work closely with you to make sure that your assets are owned properly, and then don't help you keep your plan updated. Unfortunately, that is the standard. That is what estate planning attorneys do. It's not malpractice. And this is why many estates plans fail and why they end up in court. So if you have an existing trust, mark down on your worksheet that you need your trust and your assets reviewed. So now we know what doesn't work. Do nothing, having only a will, or even having an estate plan created by a lawyer who just focused on template documents, who doesn't help you get financially organized, or who doesn't provide comprehensive guidance on how to properly fund your trust. That type of estate planning doesn't ensure the protection of your kids or your assets. These types of estate plans will not provide the coverage you need if something happens to you, will not keep your assets out of court or out of the state's Department of Unclaimed Property, and are very likely to leave your family unnecessarily at risk of a big mess in the event of your incapacity or death. But here's the thing. What you need is different than what another family needs because your family dynamics and your assets are all unique to you. And the law, as it applies to your family and your assets, are specific to your circumstances. That's why, as I stated earlier, I begin all planning with a life planning session. It's an hour-long meeting and process that my clients really appreciate because they become more financially organized than they have ever been before. And it helps keep their assets out of the state's Department of Unclaimed Property. And it includes education about how all of this works in their particular and unique situation, so that they know what they need to do to protect themselves and their loved ones. And they are empowered to make informed decisions. During that planning session, if you choose to meet with me, you're going to choose your own fee for the plan that is best fit for you, for your family, and for your budget. My average fees on these 3 levels of comprehensive estate plans run between $2,000 and $8,000, depending upon your unique family circumstances and the type of assets you own and the decisions that you make based on your situation. Most trust-based plans cost somewhere between $4,000 and $6,000, depending upon the customized asset protection features you choose to include. But what's most important is that you are the one choosing. By the end of the meeting, you will know with certainty that you are making the best decisions for your future, and your family will know how much you cared about them, because everything will be so well handled in the event of your incapacity or death. Having an up-to-date, well-funded, and comprehensive estate plan is a gift that you are giving to the people you love.